In our last lesson, we talked about the number of cases that the Constitution allocates to the federal courts. How many cases? Do you remember that? 20 powers given to Congress, 6 powers given to the President, 11 kinds of cases assigned to the federal judiciary. Remember that? Just 11, not 11,000. Today we're going to talk about the appellate powers, the jury system, and the only crime that is identified in the Constitution, and that is the crime of treason. So we'll begin on page 612. Provision 182 in the Constitution says that the Supreme Court has appellate jurisdiction. What do we mean by appellate jurisdiction? They can hear appeals from the lower courts, right? There's 2 kinds of jurisdiction. You remember this? Appellate jurisdiction and original jurisdiction. That's right. What is original jurisdiction? Right. Those kinds of cases, and there are only 2 for the Supreme Court, that have to start at the Supreme Court. They cannot start at a lower court and be appealed. Most of the cases are appealed. As a matter of fact, over 5,000 cases are appealed each year from lower federal courts. Can you believe that? 5,000 cases. Well, is it possible for them to hear 5,000 cases? No. And so, they only accept about 200 cases. What happens to all the other cases that they don't accept, that are appealed? What happens to those? The decision of the lower court stands as it was rendered. In other words, the person making the appeal loses. Everybody see that? So the decision of... So in effect, the Supreme Court is saying, maybe not directly, we agree with the decision of the lower court, but we're not going to get involved. We let it stand. All right, the other part that we need to note is that Congress may limit the kinds of cases that are appealed to the Supreme Court. This has hardly ever been done in the history of the United States Constitution, where Congress can actually say, this kind of a case, and this kind of a case, and this kind of a case cannot be appealed to the Supreme Court. Why would you think they would do that? Why would the founders have put that provision in there? To prevent overloading of the Supreme Court. In other words, Congress could have said, and could still say, that the Supreme Court may not hear cases on appeal that have to do with religious things, or with education things, or prayer in schools, or Bible reading in schools. They could say that. Do you see how they could still use part of the Constitution to correct some of the abuses that have happened? That could still happen, but Congress very seldom does that. If a judge said, which we quoted, remember, that the Constitution is what we say it is. You remember that quote? Could they not say that this provision to limit the appeals is unconstitutional? Is that what you said? Is that what you asked? Well, it's so direct in there that it would be difficult for them to do that, because it's exactly stated that way, that Congress may limit the appeals. So it would be, the fact that they haven't done it basically nullifies that provision, at least up to this point. Okay, let's talk about the requirement, which is provision 183 in the Constitution, that all federal criminal cases have to be done in front of a jury. Do you see that requirement? In other words, if the federal government is going to prosecute somebody on federal criminal charges, the Constitution requires that it always be done in front of a jury. Why do you think what's that for? The founders knew that the power of the federal government was extremely, and could be extremely, excessive. And this is a great protection, one of the safety nets of the Constitution for citizens, that the power of the federal government cannot just come swooping down onto a citizen and some judge or some politician force a decision against a citizen. But in between there The final line of defense, you might say, is a jury. We'll talk about a jury. And what kind of juries are we talking about? What is normally termed as common law jury. What is a common law jury?
That's what we're discussing.
Has anybody here sat on a jury? Probably not. You probably will, and I would encourage you to do so. It's a great experience to sit on a jury. Let me tell you what, having sat on a couple of juries, what the judge says to the jury at the end of the cases being presented. Both sides have presented their cases. Then the judge turns to the jury and says something like this: "Ladies and gentlemen of the jury, you've heard the facts. Now I will explain to you the law. Your responsibility is to decide the facts," meaning whether the guy did it or not, "based upon the law, and render a decision based upon the law that I will give you." So as a juror, you're sitting there thinking, let's see, my responsibility is to do what? Is to determine the guilt or innocence based upon the facts. In other words, did the guy actually do it or not? And the facts as presented are the only basis on which I can make a decision. Do you see that? That's the way it is today for the most part. That is not the way it was done in the days of the founders or contemplated by the founders in the Constitution. I want you to turn to page 615 in your book. So the first thing that a jury does is determine the facts. I want you to look at page 615, first column. This is John Jay, who was the first Chief Justice of the Supreme Court after the Constitution was ratified. These are the instructions that John Jay gave to the first jury trial, or in the first jury trial. He gave these instructions to the jury. See if you can pick out the difference between what John Jay said and what I have just told you is said now by the judges. He said, "It may not be amiss here, gentlemen, to remind you of the good old rule that on questions of fact, it is the province of the jury. On questions of law, it is the province of the court to decide. But it must be observed by the same law which recognizes this reasonable distribution of jurisdiction, you have nevertheless a right to take upon yourselves to judge of both, and to determine the law as well as the fact controversy." What's he saying? He says, while it's traditional that the jury decide the facts, whether the guy did it or not, and that the court give the law, nevertheless, as a jury, you have the power to determine what? Both the facts and the law. What does that mean? Yeah, let's go on here. "On this and on every other occasion, however, we have no doubt you will pay that respect which is due to the opinion of the court." In other words, I'm schooled in the law, and I hope you give deference to my opinion in the law. But you don't have to. It is on the other hand, well, let's see, it says, "For as on the one hand it is presumed that juries are the best judges of facts, it is on the other hand presumable that the courts are the best judges of the law. But still, both objects are lawfully within your power of decision." This is a tremendous power to juries. What is it saying here? Not only as a juror do you have the responsibility to decide whether the guy did it or not based on the facts, you have the power to determine what? Whether the law, as explained by the court, should even apply to this guy in this case or not. Even if he did it. You as a juror have the right to say, we don't think that law should be applied to this case. We think this is a stretch by the prosecutor. We think this law is bad, or it may even be a good law, but not applicable in this case. That is the power of a common law jury. Do you all see that? That's tremendous power. Does that mean that the jury is going to declare the law unconstitutional? No. No, that's not within the power of the jury. But the jury says that law should not apply to this person in this case. See that? That's not done in today's courts. We'll see that here in a minute. So, determine the facts and determine the applicability of the law. As we said, that's by John Jay, who's one of the founders and the first Chief Justice of the Supreme Court. Notice that the jury cannot repeal a law. And as we have said, it is one of the great safety nets for citizens against government abuses. What you're actually saying here is that a group of your peers, and we'll define jury here in a minute, a group of your peers can stand between a citizen and what? And a law passed by the majority of the people or their representatives. I mean, is that not power? That's incredible power. Well, that was the way it usually was up until about 1895, when in the Sparf case, the Supreme Court says that the jury should do what the judge says. And if the judge says you will not judge or make a determination on the law, then, or if he doesn't even explain that they can, then who knows if they can. See, that's the problem today. Juries can still make decisions based upon the law. You go into that jury deliberation room and you can say, I don't think this law should apply to this guy. I'm going to vote not guilty. Not because he didn't do it, but because I think this is a crazy law, or that this prosecutor is being so overzealous, he's just trying to get this guy. I'm going to vote not guilty. Even if he did it. See, a jury can still do that. And so you come back in and you announce your verdict of not guilty. And even our own Attorney General, and several Attorneys General throughout the United States, in different states, have said, yeah, a jury can still do that. But if the jury doesn't know they can do it, see, that's the problem. Most jurors don't know that they have this power. So if they don't know they have the power, it's basically tantamount to not having the power, and juries really lose out on a big opportunity here. Do you all see this? Okay, that's what we call a common law jury. Let's talk about the jury system in the United States. As it says on page 617, under the British Empire, many nations had a jury system. It actually mentions some here on page 617, first column. Hungary, Germany, Japan, France. Many nations have used the jury system in the past, but nearly all nations, for one reason or another, have now abandoned the jury system. Did you know that? And only in the United States is the jury system still used extensively. There are efforts in this country to abandon the jury system. Some people say, well, it's too expensive. It's too time-consuming. It takes a lot of time and a lot of effort to assemble juries. And it is expensive. And so for those reasons, at least that's the ones that they indicate, the jury system, every once in a while you'll see in some legislation doing away with certain parts of the jury system. But as we said, the United States has 90% of all the jury trials in the world today. So, and how many is that? About 120,000 jury trials are done in the United States. In your city, right here in our city, you can have a jury trial in the municipal court. Okay? It's not done a whole lot, but you can still have it. I've sat on one of those many years ago. You have jury trials in superior courts. You have jury trials in state supreme courts. You have jury trials in federal courts. Lots of opportunity for jury trials. Okay? Now, the question is, what is a jury? We say it's a jury of your peers. Who are your peers? People who
know you.
Okay, people who know you, your neighbors. Look at let's look at some quotes here. On page 617, down at the bottom, who should serve as juror? Second column. You see that? Mr. Henry says, by the Bill of Rights of England, a subject has the right to a trial by his peers. What is meant by his peers? Those who reside near him, his neighbors, and who are well acquainted with his character and situation in life. What do you think? Why would they be the best people to judge you?
Because they know your character.
They know the real you, what you're like over years. Would you want somebody to judge you who really knows you? Careful, would you? Would you like for example, look at the next quote by Mr. Henry. Why do we love this trial by jury? Because it prevents the hand of oppression from cutting you off. Has not your mother country magnanimously preserved this noble privilege upwards of 1,000 years? This is the English. This gives me comfort that as long as I have existence, my neighbors will protect me. Isn't that a beautiful concept? Who do you want to judge you? Your neighbors, right? What does that mean you better be?
A good neighbor.
A good neighbor. Right? So what is it evolved to today?
They can't, if they know the person.
Now, today, if you know the person, that's the first thing you do. Do you know this person? Yes, I know that person. They dismiss you from the jury. In other words, they're so caught up with juries being persuaded or tainted or subjective. They want to find people who know nothing, who know the person, who know nothing. It's incredible the kind of questioning you go through as a potential juror, thinking that they can find somebody objective. It is not the purpose of jury selection to find people who know nothing. It's the purpose to find them who know this guy and know really how he is. Do y'all understand that? That's really changed, hasn't it? Okay? So, the whole purpose of juries was designed for local justice in small counties. And that's really where justice should best be meted out, in your local communities by people who know the real you. No, he wouldn't have done that. No, I know him better than that. Go to church with him every Sunday. My children are over there all the time. No, That's somebody is trying to get this guy. He's not like that, really. I know him. If you don't know him, how can you say that? Can't. So that's what we call a jury of your peers. Okay? Provision 184 on page 620 says that trials are to be in the state where the act was committed. Why in the world would you do that? One of the favorite things of King George was to arrest colonists and take them to England for trial. That's real great when you're trying to get together a jury of your peers, right? Well, who's over in England? You're putting together your defense? And where are you going to get your witnesses for your defense? In England. See, and the founder said, we'll have none of that stuff. The trial is to be held in the state where the act occurred. Has that been changed a little bit? Yes, the Supreme Court has ruled that in some circumstances, for example, in the Oklahoma City bombing, which happened in Oklahoma, where was that trial? In Colorado. Thinking that, well, there's too much tainted media coverage and so forth in Oklahoma, like as though there weren't in Colorado, but anyway, they changed the venue there. But Constitution says the trials are to happen in the state where the act was committed. Lots of things are made easier by that. Gaining witnesses, gaining a jury, a proper jury, etc., etc. And if it's outside the state, Congress can designate a place. If an act occurs outside of any state, you see that? If it's on the high seas, then Congress can determine where the trial is. These are still federal trials, though, we're talking about, right? Okay. The Constitution was never meant to be a listing of do's and don'ts. It was never meant to be a law book in the sense that laws are defined and punishments are defined. So that's not the purpose of the Constitution. It was to set up the structure of government. But there was one crime that was so abhorrent to the founders and so misused and misapplied by King George that the founders said, we're going to put it right in the Constitution. We're going to make an exception and put it right in. And that was the crime of treason, for which King George had 17 different kinds of offenses under which he could charge treason, and did. 17! I mean, almost anything you did, you would be afraid of being charged with treason against King George. And the founders said, no, we're not going to let that go. We're going to very narrowly define this most dastardly crime of treason right in the Constitution. And so, that's what they did. As we said, it's the only crime defined in the Constitution. And how did they define it? Levying war against the United States. Or what? Giving aid and comfort to the enemy. Well, that's interesting. Have you ever heard of people giving aid and comfort to our enemy?
Yeah.
In your lifetime?
Yeah.
You say, wait a minute. Why haven't they been charged with treason?
Because the president.
Well, why haven't they been charged with treason? A very good answer to that, because the Supreme Court ruled if there is no declared war, there can be no enemy. Do you understand that? I mean, do you understand the words? It's hard to understand, but in other words, the Supreme Court says you cannot charge anybody with treason, which is defined as giving aid and comfort to the enemy, if there is no enemy, because we have no declared war. When's the last time we had a declared war? World War II. All the wars, all the enemies we've had since World War II, no one has been able, except in one case that I'll tell you, actually since the Supreme Court ruled this, no one's been able to charge somebody with treason.
Have they done it?
So, in Vietnam, for example, when our men are over there being killed in South Vietnam, and Jane Fonda makes her way over there to the North Vietnamese communists, our enemies, and tries to persuade our men to go back home because this is immoral and the people in the United States and your families don't want you over here and so forth and so on. When she is working for the enemy, what happens to her? Not a thing. Because there is no enemy under which you can charge treason. This is incredible, isn't it? And so, we say there was no treason in Korea and Vietnam when Americans helped the enemy. And as long as the Supreme Court decision stands, that will continue to be the case if there's no declared war. And do you think there will ever be another declared war under current situation? No, because we've kind of abandoned that whole concept in the Constitution. Okay. What factors have to be present in order to charge somebody with treason? Provision 187 says that you cannot charge somebody with treason like King George would almost at a whim. You have to have 2 witnesses or there has to be a confession in open court. What does that mean, confession in open court?
Yeah, confess to treason in front of the jury.
Yeah, a public confession, right? Or there has to be 2 witnesses. Otherwise, there can be no conviction of treason. See, that just cut the legs out of this King George approach. You go around, you don't like somebody, charge them with treason against the king. Okay? This was very narrowly defined. Okay? And Congress, provision 188 says Congress is the one to set the punishment for treason. And what was generally throughout our history the punishment for treason? What did Congress declare? Punishment is death, or imprisonment and fine, but usually death. And this is serious business. Treason against the United States means that you are actively helping to overthrow the United States of America and its Constitution. And so that's one of the most serious things that could happen. Okay? Now I want to talk about the case of Julius and Ethel Rosenberg. Do you remember those in American history? Julius and Ethel Rosenberg, their picture there is on page 625. After World War II, it became known that the Soviet Union had nuclear capability, or was heavily involved in developing nuclear bombs. They could make a nuclear device, but they couldn't, anybody know this? They couldn't detonate it. Didn't know how to trigger it, which is kind of a tricky thing, right? They didn't know how to trigger it. Well, how did they get the knowledge to trigger the atomic bomb? Julius and Ethel Rosenberg stole those secrets from the United States and gave them to the Soviet Union, which really brought about a probably 10 or 15 year what should we say, move up in the time that most people thought the Soviet Union would get nuclear power, the ability to detonate a nuclear bomb. Anyway, they were convicted. It says, I'm down about halfway down the first column on 625. At the time, the FBI identified the 2 spies who had helped the Soviet Union get the plans for the detonator. They were Julius and Ethel Rosenberg. They were tried and convicted in 51 and executed in 53. Although there was a worldwide campaign to have their sentence commuted to life, the execution took place. Now I want to read this with you. The judge's decision to sentence them to death. This is powerful. This is Judge Robert Kaufman, who said this: plain, deliberate, contemplated murder is dwarfed in magnitude by comparison with the crime you have committed. What's he saying there? You haven't just committed murder. I mean, just a murder is dwarfed in magnitude with what you have done. I believe your conduct in putting into the hands of the Russians the A-bomb years before our best scientists predicted Russia would perfect the bomb has already caused, in my opinion, the communist aggression in Korea, with the resultant casualties exceeding 50,000. And who knows but that millions more of innocent people may pay the price of your treason. Indeed, by your betrayal, you undoubtedly have altered the course of history. What I am about to say is not easy. I have deliberated for hours, days, and nights. I have searched my conscience to find some reason for mercy, for it is only human to be merciful, and it is natural to try and spare lives. I am convinced, however, that I would violate the solemn and sacred trust that the people of this land have placed in my hands were I to show leniency to the defendants Rosenberg. It is not in my power, Julius and Ethel Rosenberg, to forgive you Only the Lord can find mercy for what you have done. You are hereby sentenced to death. That's pretty powerful, isn't it? Julius and Ethel Rosenberg. Okay, the last provision we'll just mention. Provision 189 is there is to be no attainder of treason. What in the world is attainder of treason? That's the bill of attainder, where you just pass a law saying, what is attainder of treason? Attainder means, you remember? Fingering, putting the finger on. Attainder of treason, whereby the penalty shall extend to the forfeiture of property or any other penalty beyond the life of the accused. In other words, if you sentence somebody and give them a penalty for committing treason, it cannot extend past the life of the accused. What if it did? How could it extend past the life of the accused? To the children by what? Yeah, by confiscating property so that it cannot then be passed on to your heirs even after you're dead. You see, then the heirs would be punished for the sins of the parents, right? Is that a good concept or a bad concept? Men should be punished for their own sins, right? And not be affected for generations to come. This is right in the Constitution. And so, we found this after the Civil War. You remember one of the retributions that was demanded of the South was that property be confiscated. Property of those who were leaders in the South who had led the rebellion. Their property was confiscated. After they died, their heirs, their children and heirs, went to the Supreme Court and said, we should get our property back because the Constitution said there shall be no attainder of treason beyond the life of the accused. Guess what the Supreme Court ruled? They agreed with them. So their property was returned. The heirs of the Confederate leaders whose property was confiscated because of their rebellion. Everybody see that? If you punish somebody for treason, it can only affect the person who actually did it and not their heirs. Okay? So that concludes our discussion of this chapter and of the only crime in the Constitution which is defined and the punishment is defined, and that's treason. Thank you very much.